the final case of the morning for the court is State in re DT. And the court has read the briefs and is prepared to hear argument. I want to give you just a couple instructions, especially since this is a juvenile case. We're not to mention the names of any juveniles and also the victims, obviously. We don't report them in our opinions, and we really don't we want to make sure that they're not mentioned on the video recordings that's posted on YouTube. So each side will have 15 minutes, and the appellant may reserve up to 5 minutes. Just please let me know how much you want to reserve. Thank you. You may proceed, I'm sorry.
Okay. Thank you. I would like to reserve 3 minutes for that.
Okay, thank you.
Your Honors, may it please the Court. My name is Victoria Ferry, and I'm here today representing the appellant DT in this case. DT respectfully asks this Court to reverse the juvenile court's decision for 2 reasons. 1, the trial court erred in failing to suppress DT's statements to the police because they were involuntary and obtained in violation of his right to due process. And 2, the trial court erred in failing to suppress DT's statements to police because they were obtained without a valid Miranda waiver. On December 3rd, 2019, 13-year-old DT was taken into a room with an investigating detective. The detective then shut the door completely closed. Much like the facts of JBB, where a 13-year-old student was escorted by a police officer to a closed-door conference room, this 13-year-old was escorted into a closed-door room with an adult detective. Despite bringing DT down for the sole purpose of a forensic interview, the detective assured DT that he was, quote, there to help people. But by the detective's own admission at the suppression hearing, he said, quote, it was possible that DT could have thought he was not free to leave, so we started with the Miranda warnings, to which DT responded only with, uh-huh. The detective repeatedly made comments throughout the course of the interview, insisting that DT had to talk. But DT did not want to talk, and expressed that to the detective. Again, by the detective's own testimony, DT was very quiet, reserved, and his answers became either inaudible or very mumbled and hard to stand. In response to this change in behavior, the detective took a break and then proceeded to move his chair within 2 feet of DT to create a, quote, closer environment, and then proceeded to place a hand on his leg. During the course of the interview, DT indicated he wanted to lead, but despite this desire, the detective continued on for the interview for a total of 90 minutes. The detective's line of questioning was designed to not only find out what happened on November 26th, but more specifically to elicit confirmation from DT that he had in fact committed the acts alleged in the referral. In my first assignment of error, DT's confession was involuntary. It was obtained as a result of police coercion. In this case, the evidence is that the law enforcement coercively elicited incriminating statements from DT. On an appellate review, this suppression motion presents a mixed question of law and fact. As such, this court must review de novo, meaning that they must independently determine, without deference to the conclusions of the trial court, whether the facts satisfy the applicable legal standard. Here, the test for a voluntary confession is whether that action was voluntary under the totality of the circumstances. The totality of the circumstances are determined not only by the circumstances and details of the interrogation, but also of the juvenile's unique characteristics.
Counsel, before we get into that, before you can look at the totality of the circumstances, don't you have to demonstrate coercion?
Yes, Your Honor, and that is...
Where's the coercion here?
This is done by the police officer repeatedly telling him that he needed to talk. Not only that, but the length of this, and he brought up several times that he also threatened that, you could go to jail for this, and it was insistent that he must talk. And because of that, it triggers the totality of the circumstances analysis.
Do you think the name of the center where he was interviewed plays into that as well?
the Child Advocacy Center?
No, Your Honor, I don't believe that it does. Much like JDB, where there is a classroom present, we're still looking at a reasonable child standard here. And although this was similar to JDB, again, with the door closed without a parent present and the length of the interview, we do not believe it plays in here. At the time of the December 9th interview, DT was only 13 years old. And age is particularly important when assessing the truthfulness of the statements obtained. Young people are especially prone to confessing falsely. Children account for as far as a third of documented false confessions. Those under 15, like DT, are especially at risk. And these incriminating statements often lead to a plea or conviction. Unlike the safeguards afforded to child victims and witnesses, the juvenile justice system has failed to develop extensive protocols. Instead, they take advantage of the psychological reality that children are more susceptible to police interrogations. Training instructs officers to treat children no differently than they do adults. Again, here the detective employed coercive tactics without the appropriate safeguards. Despite the DT's age at the time, the questioning was conducted in the absence of any parent or guardian. In fact, the detective at the suppression hearing testified that he was completely unaware of the parent's location. The detective even admitted that DT did not want to talk about it. In the middle of the interview, the detective again described that he had become quiet and reserved and had demonstrated these nonverbal cues that he did not want to continue.
I know you said the testimony of the police officer was they didn't know where the parents were. Was there any testimony as to who dropped him off or whether he was in custody at that point?
I believe in the police report they documented that the mother did, but when he testified at the September 1st hearing, he could not remember.
Thank you.
So again, under the totality of the circumstances, given the circumstances of the interview, along with DT's age, the absence of his parents, the duration of the interview, leads to the conclusion that these statements were not voluntarily made. As these statements were not made by DT's own free will, the lower court erroneously denied the trial court's motion to suppress. In the second assignment of error, DT's statements to the police were obtained without a valid Miranda waiver. The state's argument that DT was not in custody was unfounded. In this case, under the Miranda analysis, DT was in custody. This is further informed by JDP-B, and that the appropriate test deemed by the Supreme Court is whether a reasonable child would feel free to leave the situation. So this court must determine how a reasonable child would have understood this questioning. Here it is clear that a reasonable 13-year-old child, alone in a room with an adult detective, would not feel free to leave this interview. Given the presence of an authority figure, a child in this circumstance would feel pressure to stay and submit to the officer's questioning. Moreover, the detective repeatedly made comments throughout the course of the interview, insisting that DT had to talk. A reasonable child would be susceptible to such comments and not feel free to leave and stop the interrogation. For these purposes, DT was interrogated. An interrogation is defined by any statement, question, or remark which is reasonably likely to elicit an incriminating response. From the onset of this questioning, the detective inquired about what happened. The detective went on to tell DT that he was already aware of what happened and he knew the truth. The remaining question consisted of the detective assuring that DT he was there to help, but he needed to know what happened.
But the factors you're talking about go more to involuntary or voluntary, don't they?
As far as whether this was,
you're talking about Miranda here, so they did give him a Miranda warning. Okay.
Yes.
So you said there's complete evidence he was in custody. Okay, well, they gave him a Miranda warning. What was wrong with the Miranda warning they gave him?
This was not done knowing and intelligently. Again, we're looking at the totality of the circumstances here, and although he said, we look at other instructions for court testimony that direct witnesses to say a clear yes or no. And given the importance of upholding this right, again, we should be looking that the waivers are unequivocal and definitive. And here, given that DT's young age, this is not a knowing and intelligent waiver of his rights.
I have a question going back to the special characteristics of the child. Is there anything on the record that this child has special characteristics like a special need or disability?
So later in the proceedings, there was a competency determination and he was found not competent, and so he had to acquire that.
On what basis? Like that he had some type of special need? And he couldn't understand the proceedings or his age? And what's particular about this child?
I believe it was the age, and I believe he does have some attention deficit, and that contributed to his difficulty with understanding it. But it was primarily the age of the child.
But he was only, he was restored to competency within just, what, a few months?
Yes, that is true, Your Honor.
Okay.
Moreover, we have to look that children misunderstand these Miranda warnings at alarming rates, and many developmental psychologists question whether minors are ever truly competent to make this knowing, intelligent, and voluntary waiver. So again, under the totality of circumstances, DT did not knowingly and intelligently waive his Miranda rights. At the time of the interrogation, DT's age was known to the detective and readily apparent. During this time, the detective gave DT his Miranda rights, but again, he responded with At no point did DT verbally express that he understood his rights or affirmatively reject the offers made. As such, the lower court erroneously denied the trial counsel's motion to suppress. If there are no further questions, I would like to save my remaining time. And therefore, DT respectfully requests that this court vacate the judgment and remand for further proceedings.
Thank you. You have 342 left. And the state will have 15 minutes.
Thank you. Good morning again. Mark Cozen on behalf of the Lorain County Prosecutor J.D. Tomlinson and the state of Ohio. May it please the court, we ask this court to affirm the magistrate and trial court's decision in not suppressing DT's statement. Looking at the assignment of error, the first issue is whether or not coercion, and the state was, if it was a coerced statement, and then the test would go to look at the totality of the circumstances, where you look at age, length of interview, frequency, threats, physical, but the state rejects that we would have to get to the totality of the circumstances because we don't believe there was evidence of police coercion.
Do you think manipulation is coercion? Like if you're going to a child advocacy center and you say, if you don't continue with this interview, you'll go to jail, I'm just trying to help you.
I would actually argue, Your Honor, that taking them to the North Center would actually be a place of comfort, not to manipulate for coercion, but to make him more comfortable, to make it a less coercive
But
environment.
child advocacy and you're a child, wouldn't that connotate that place is there for you?
Yes, and I can understand how that could become a manipulative environment, that you would feel that you would have to come forth and say that, but I would say that the fact that this was a room with toys, he was brought there voluntarily, that it was a room of comfort for him to tell the truth, that it was not a manipulative or coercive effect of the police. I would argue that under the coercion, we'd have to have physical abuse, threats, deprivation of medical treatment, or sleep, and none of that took place here. As I described, his parents voluntarily brought him there.
And how was that brought forward?
I believe it was in the trial testimony on the transcript on page 6. I can, from the record.
The detective testified
Testified.
that the parents brought the child in, or the mother at least.
That is.
Well, going back to Judge Lanzinger's question, in regard to manipulation and psychological coercion can be a grounds. It can be coercive if it's psychological as well.
Yes.
Would you agree with that?
I would agree with that, but I don't believe that took place here, as Detective Garland in his testimony, if there was any issues, would stop, have him talk about toys or video games and these stuff. If there was some kind of issue, he would stop. He repeatedly told them, I know we're not at this point, but he was free to leave. And additionally, so no, I don't believe there's any coercive. I think he was just trying to make him comfortable to come forward and speak.
Counsel, yeah, and again, going back to Judge Lanziger's question in regard to where he was interviewed and so forth, the officer, having reviewed the video, almost was like the officer was interviewing a victim. Tried to make me very comfortable. I'm only trying to help you. You need to just tell us the truth because we know what happened anyway.
I can understand that, and the Nord Center is typically a facility for victims that come over, children or sexual assault victims. But I think taking him there is a step towards building trust with the child to make them comfortable, that it's not coercive.
So why do you have to develop trust when you're interested in the child and they're not alive?
Well,
You develop trust when you're dealing with a victim.
I agree with you, but if you were to talk to the kid to get any kind of statement, I believe that him, by talking to him to build that trust, is just to get this child to speak with him. As he was in plain clothes, the parents brought him there, the thing, he was not handcuffed, Your Honor. I do not believe at all that this manipulation was going towards coercion. This was a place that was not to scare him, but to get him to come forward and just speak with the detective.
I saw you make a face when I asked about the special characteristics of the child. Do you know what I'll find in the record when I start looking at whether there were special characteristics like a diagnosis or low IQ?
Your Honor, if I made a face, I
All right,
apologize.
okay.
I was not reacting to that.
I thought maybe you thought there was more to that.
No, I think, I was not reacting to that, Your Honor, I apologize. I'm not fully sure what was the basis for it needing to be restored. I'm not sure if it was age or any of these things. But obviously that wasn't known at the time. It came about 9 months later.
It seems that would be very relevant, like if he had autism or a lower IQ.
Yes, and
If it didn't come to play, maybe that wasn't there, but
I just, from the record and from my understanding, I don't think the detective was aware of this. The parents didn't bring this forward. I mean, the child was brought there by the parent, actually spoke to one other officer beforehand before he spoke to.
right, but he doesn't, according to the briefs, the officer did his version of it, whether this kid understands the proceedings, or understands this, and it was just like, do you know this is an animal and this is what color is this kind of test? So, was there any inquiry into his capacity?
I believe that beyond the record, Your Honor, I'm not aware of that.
Well, I have a follow-up again.
Of course.
We're putting you on the hot seat today.
That's-
So if he's found incompetent at the hearing, when he's going to be adjudicated, how could he have been competent to waive a Miranda warning?
Well,
Or waive his Miranda rights, I should say.
I would argue that one, if we were to look at the totality of the circumstances, specifically if he's in custody or whether or not there was a waiver, he did not present anything to the officer to indicate to any of those things that there could be an additional issue here. He understood the questions, he seemed calm, he wasn't upset. So based on what the officer knew at the time, I don't think it became an issue of if this child was competent or something.
But does it really matter what the officer knew at the time? The point is, if the individual, be it an adult or a child, but especially a child, if they're found incompetent, I'm still puzzled by how in the world you can say they were competent to waive constitutional rights. Because it is a knowing, intelligent, voluntary waiver.
Correct, Your Honor, and we cited it at the end of our brief, Your Honor, when we were looking at that, the factors you look at when considering those certain circumstances, especially here in, I believe it's Kirk and Gardner, where when considering the circumstances, the suspect's conduct, speech, and appearance at the time of the interrogation has primacy over his diminished capacity, especially when the suspect did not exhibit any outwardly observable indications that he did not understand the warnings or circumstances surrounding the interrogation.
Well, he did say several times he didn't want to talk.
That is correct, Your Honor.
And the officer just kept saying, well, you need to.
Yes,
And then he also said that multiple times, he just doesn't remember. He didn't look at the officer, he looked away, he kept looking at the floor. How do you respond to that?
Obviously, I was not in the room at the time, I did not watch I'm just going off the transcripts and the brief that was filed, but, Your Honor, based on the testimony of the officer that came out, that I don't believe he was trying to push him into saying more than he wanted to, or try to convince him into saying some kind of statement. I believe it was just dealing with a child who didn't understand, Your Honor.
Does it come into play the sophistication of the defendant, or in this case, the juvenile, that in regard to their understanding, would that be a factor you looked at?
As we cited further at the end of our brief, that the suspect with diminished capacity evaluated when he understood the warnings and had previous experience. I know that case is a little off, but he was previously warned of his Miranda rights by another police officer, so he was familiar with police. Unfortunately, Your Honor, I don't have the answer to that question. I would have to, if you request, I can brief it for you.
That's okay, I was just wondering, because in watching the video, this is, a 13-year-old doesn't even look 13, looks like he's 10. So I'm just wondering about the sophistication and what was presented in regard to that. Thank you.
Additionally, getting back to the argument specifically, he did waive Miranda, I believe he did understand that. Then the issue would come on to custody. He was free to leave. We talked about the playroom. Additionally, appellant continually just relies on age, and that the parental parent is a prerequisite, but that is not in the case law, that is fully necessary. I believe the continual citing of JMB, that age is not a determinative or even significant factor in every case. Not that it's not a factor, but it's not the most significant factor. Additionally,
In the presence of parent at the interview, in the presence of a parent at the interview is not dispositive, but it is a factor. So you've got a young child with no parent or nobody, such as an attorney or anybody in local parentis to protect his rights.
The parent brought them there voluntarily. They were in the room. I understand the record was the detective may not have known where the parent was, but the parent had brought them there.
There's a case law that talks about the fact that if the parent brought them and this child is not of driving age or, able to just, that the courts look at that the child is not able to leave on their own because the parent is the one that brought them, so they can't just leave.
I'm not familiar with that case. I appreciate it bringing it to my attention, but I would still argue that he was told he was free to leave in that room.
Well, he was told he was free to leave, and then when he wanted to leave, he kept talking to him. That would seem to me a 13-year-old might be kind of confused about the fact that when you say you're free to leave, and he says, I'd like to leave, and you don't let him, that perhaps he's not able to leave.
I can understand that presumption of whether or not, but I think as the detective testified, he had no indications. The child seemed to understand what was happening. So from his saying, if they said he was free to leave, but then wanted to continue to talk, there was no dispositive statement that the interview must be ended by the child. Based on that, thank you.
Thank you. You do have the 3 minutes and actually 41 seconds. If you want to, measure it up.
I would just like to clarify a couple of points. The first being whether we even trigger the totality of the circumstance here. And again, cited by the Supreme Court in JDB and in many cases, it talks about how interrogations are inherently coercive. And then we add that, a child is in a room alone and being, threatened with jail and having to tell the truth and knowing what happens We do argue that there was coercion here. Again, especially as I mentioned earlier, what we know about children's tendency to kind of submit to authority and wanting to tell the truth and to help themselves.
But it seems like your argument with the statistics on children seems like you're arguing more that anytime a child is present for an interview without an attorney or without a parent, that it's going to be a coercive environment, and we should trigger the totality of the circumstances.
I would not say every circumstance, but especially here. Again, especially what we know about children that are under 15. And here we have that DT was 13 years old here, but without a parent. And as far as the competency evaluation, I was briefly reviewing the transcripts, and I know the magistrate found that there was a preponderance of evidence to complete this competency evaluation, and found that he was not competent but restorable.
But did it say, I didn't have a chance to say for what reasons?
Not on the transcripts,
All right.
in particular, it just said a reasonable basis. The next point I wanted to bring up, and this is as it pertains to the custody analysis, it should be noted that the magistrate decision that was also adopted by the judge here does not specifically cite to JDB, specifically to the reasonable child standard here. And although this is, as the state mentioned, not in every case, I think it's particularly important here, especially as we think about how similar the facts were to JDB to this case. If there are no further questions, Your Honors, I would just like to briefly conclude. And for these reasons, we respectfully ask that this court reverse this decision or remand for further proceedings. Thank you.
Thank you. Thank you both for appearing today and taking the intense questioning, so I appreciate that. And the court will take the matter under advisement, will issue a written opinion, and it will be sent to both sides as well as released on the Supreme Court website. Thank you very much.